Good day. We are Group 1 from Election Law SPL2, and today we will be discussing Certificate of Candidacy. First, who is considered as a candidate? According to Section 79A of the Omnibus Election Code, a candidate is any person aspiring for or seeking an elective public office who has filed a certificate of candidacy by himself or through an accredited political party, a groupment, or coalition of parties. A certificate of candidacy is a statement of a person seeking to run for a public office certifying that he announces his candidacy for the office mentioned and that he is eligible for the office, the name of the political party to which he belongs, if he belongs to any, and his post office address for all election purposes being as well stated. Now, what is the basis of a certificate of candidacy? According to the law, no person shall be eligible for any elective public office unless he files a sworn certificate of candidacy within the period fixed by the Omnibus Election Code. Now, Section 73 of BP 881 or the Omnibus Election Code provides for the rule of one person, one office. According to this rule, as a general rule, no person shall be eligible for more than one office to be filled in the same election. And if he files a certificate of candidacy for more than one office, he shall not be eligible for any of them. As an exception, however, under the law, before the expiration of the period for the filing of a certificate of candidacy, the person who has filed more than one certificate of candidacy may declare under oath the office for which he desires to be eligible and cancel the certificate of candidacy for the other office or offices. When is the deadline for filing of a certificate of candidacy? The Commission on Elections shall set a deadline to ensure that the official ballot shall contain, first, the titles of the positions to be filled, and second, the names of all candidates for the same position arranged alphabetically by surname and uniformly indicated using the same size type. As for the contents of a certificate of candidacy, the certificate shall state the following. The person filing it is announcing his candidacy for the office, that he is eligible for said office, and if a member of the Batasang Pambansa, the province, including its component cities, highly urbanized city or district or sector which he seeks to represent, political party to which he belongs, civil status, his date of birth, residence, his post office address for all election purposes, his profession or occupation, that he will support and defend the Constitution of the Philippines and will maintain true faith and allegiance thereto, that he will obey the laws, legal orders, and decrees promulgated by the duly constituted authorities, that he is not a permanent resident or immigrant to a foreign country, that the obligation imposed by his oath is assumed voluntarily without mental reservation or purpose of evasion, and that the facts stated in the certificate of candidacy are true to the best of his knowledge.
What is the importance of a valid certificate of candidacy? So the filing of the certificate of candidacy is mandatory under the law. However, this should be distinguished into two periods. First, before elections, it is absolutely mandatory, and after elections, it is directory. The following are the importance of a valid certificate of candidacy. First is to enable the voters to know, at least 60 days before the regular election, the candidates among whom they are to make the choice. Second is to avoid confusion and inconvenience in the tabulation of the votes cast. About the withdrawal of certificate of candidacy, a person who has filed a certificate of candidacy may, prior to the election, withdraw the same by submitting to the office concerned a written declaration under oath. It can also be filed directly with the main office of the Comelec, the office of the regional election director concerned, and the office of the provincial election supervisor of the province to which the municipality involved belongs, or the office of the municipal election officer of the said municipality. The effect of such withdrawal shall not affect whatever civil, criminal, or administrative liabilities which a candidate may have incurred. The duty of the COMELEC. Under the Section 76 of the Omnibus Election Code, the ministerial duty of receiving and acknowledging receipt, the Commission, Provincial Election Supervisor, Election Registrar or Office designated by the Commission or the Board of Election, inspectors under the succeeding section shall have the ministerial duty to receive and acknowledge receipt of the Certificate of Candidacy. It further provides that the COMELEC has a ministerial duty to receive and acknowledge receipt of the Certificate of Candidacy. This then implies that the COMELEC does not have discretion to cancel a Certificate of Candidacy, except that a Certificate of Candidacy may be denied in due course or cancelled if the Commission determines that false representation as to material facts was made in the Certificate of Candidacy.
Now, we go to a case wherein the Supreme Court emphasized the ministerial duty of the COMELEC, especially regarding certificates of candidacy. So this is the case of Abcede versus Imperial, where Alfredo Abcede in 1957 filed with the COMELEC his certificate of candidacy for President of the Philippines in the elections on November 12 of the same year. However, the COMELEC did not give due course to his COC on the ground that the same was filed for ulterior motives other than a bona fide desire to obtain a substantial number of votes of the electorate. In the ruling of the Supreme Court, it cited Section 37 of the Revised Election Code, wherein it provides that the COMELEC shall have the ministerial duty to receive the certificates of candidacy and to immediately acknowledge receipt thereof. So this foregoing provision gives the Commission no discretion to give or not to give due course to Abcede's certificate of candidacy. The Supreme Court further said that the COMELEC has no discretion to give or not to give due course to COCs. They emphasized that the duty of the COMELEC to give due course to COCs filed in due form is ministerial in character, and that while the COMELEC may look into patent defects in the COCs, it may not go into matters not appearing on their face. The question of eligibility or ineligibility of a candidate is thus beyond the usual and proper cognizance of the COMELEC. That ends our report. Thank you very much.